Okay, looks like we have most everybody in. I am Pastor Caitlin Trussell, and I just want to welcome you to this press conference, this exciting moment with legislators and experts and press and community members. I'm going to hand it off to our communications manager right away to tell us how Spanish translation works, if that's a need for you.
Morning, folks. Welcome. I'm actually going to let our interpreter, Alejandro, give the instructions. He's going to do it in English and then in Spanish, and then I'll hit the interpretation and we can pick our languages, but I'll let Alejandro describe it a little bit more. Go ahead, Alejandro.
Thanks so much. Buenas tardes. Vamos a estar proviendo servicios de idioma en español e inglés. Por favor, cuando se encienda la opción de traducción e interpretación, va a haber un globo a la parte de abajo y puedes encender o elegir ese globo y elegir su idioma de preferencia, inglés o español. Thanks so much. Bravo Savio will be providing language interpretation for today's press conferences when the Sorry, did I go off of mute there? Pardon me when everything got switched. Pardon me. All right, folks, Bravo Sabio will be providing language interpretation. When the interpretation feature is set up, you will see a globe at the bottom right. For interpretation, a globe icon, please choose your dominant language. When I click in about 4 or 5 seconds, this icon will appear. I'll repeat that in Spanish really quickly because of the cutoff. Vamos a estar proviendo servicios de idioma entre inglés y español. Por favor, mira para abajo. Vas a ver el globo.
Thank you so much. I also want to let you know that we are in a webinar format today, and specifically in the Q&A. And I know for some of our guests who are really used to certain kinds of meetings, this may be unusual. But for the Q&A, we would like to invite press only to ask questions at the end, and there'll be a time when you'll be directed to do so. But you can put those in the Q&A along the way. Although we won't be addressing those questions until the end of the press conference. So there's that. I think I have addressed all of the housekeeping. I am Caitlin Trussell. I am a pastor with Augustana Lutheran Church, and I'm a volunteer organizer with Together Colorado as a faith leader. And I want to thank the many, many people who helped put together today's event. There are a lot of people behind the scenes. And we wouldn't be here without many hands making light work for sure. I'll be moderating today's press conference, and the topic specifically is House Bill 1142. And I just want to say really specifically, you'll hear this again, this is a grassroots issue that grew into solutions from the community. Part of what makes it exciting is that there was a problem identified and lots of work over the last few years to find solutions and resolutions. Our immediate goals include the passing of this bill into law, and maybe an even more immediate goal is to respect everybody's time by reminding speakers to stay within their allotted time. So occasionally you might hear me say, when a speaker has come to an endpoint, you might hear me say thank you, and then I'll say another thank you, and then I might say thank you, time for the next speaker. Try to do that graciously. Also want to let you know that we've been collaborating with law enforcement, and they are not able to be here as they are attending Officer Talley's funeral in Boulder later this morning. There are also press who were reassigned to his funeral, who were planning on attending this press conference. And so this will be recorded and made available to the press who are here and who were not able to be here this morning. We are grateful for the members of the press who were able to join us this morning. And again, we'll have a time for questions and answers at the end of the conference. And I just want to say, in light of everything going on in Boulder and Atlanta, in the country and in the world, that this press conference reminds us that in the midst of dark times in the world, there is still light. As we say in my tradition, the light shines in the darkness, and the darkness did not overcome it. And just a word about Together Colorado. Together Colorado is a multi-race, multi-faith, statewide organization spanning 220 congregations, schools, and faith leaders, from Pueblo to Grand Junction to Fort Collins. Our grassroots leaders have been organizing systemic change over the past 40 years on a variety of issues, including housing, criminal justice, immigration, healthcare, and climate justice. Together Colorado is a member of the national network Faith in Action. And I've already introduced myself, but I just want to let you know who's here and who will be speaking today. We have Representative Jennifer Bacon and Senator Julie Gonzalez, the bill sponsors. Sharon Battle is a community organizer and an impacted person by this issue. Our experts today are Amelia Power, a former public defender and founder of Power Law Firm, a local criminal defense firm. And Christopher McKee is a nationally recognized expert and consultant on forensic science evidence. Since 2009, Mr. McKee has taught at Colorado Law as an adjunct professor. His scholarly focus is on the intersection of evidence, science, and criminal law. He's been a practicing attorney since 1997. And we have Marilyn Ackerman, organizer and member of the Montview Presbyterian Church. And I would also say, just briefly, we have Trudy Gigi, who is my assistant moderator and who will be helping keep us on track this morning. So Marilyn, I would turn it over to you for an explanation about Showups.
Marilyn, you're muted.
Yep. I'm going to start by giving the definition of a Showup. And a Showup is an identification procedure in which an eyewitness is presented with a single subject in person for the purpose of determining whether the eyewitness identifies the individual as the suspect. I'm here today as a volunteer organizer representing Together Colorado. One of our goals is to reduce incarcerations by 40% over the next 10 years. We are working to gather support for House Bill 1142 today as one step towards that goal. We would like to thank Representative Bacon and Senator Gonzalez for partnering with us by sponsoring this community-led solution. Together Colorado would also like to thank Representative Weissman for his partnership with Together Colorado on this issue over the many years. Our organization learned about Showup identifications almost 3 years ago now, when one of our members' son was wrongfully arrested for a crime he did not commit when the Denver police detained him through this Showup. You will hear his story later. We have conducted extensive research that includes case law, other state statutes, scientific evidence-based research. We interviewed and met with experts in Colorado and across the United States. Through all of this, we learned that both in Colorado and in the nation, there is little to no standardization on policies and procedures for law enforcement on Showups, nor is there information reported. States are going beyond the US Supreme Court case law and providing greater protections from the harmful and biased methods of Showups. Showups are inherently suggestive and more likely yield to a false identification. Showups are racist in nature and disproportionately impact Black, Indigenous, and people of color, BIPOC, and low-income people. Most important, Colorado had addressed this issue in 2015 by passing legislation to create best practices for eyewitness identification. Those policies were scheduled to be reviewed 5 years later. What was missing was the requirement to adopt and follow those best practices. There is no accountability, no data collection, and no follow-up review with changes made to the public. Together Colorado was determined to make a change and set out to use the tools we know best: community organizing and relationship building. We started our conversation with Denver Chief of Police Pazin, DA McCann, and Attorney General Phil Weiser, and we held a public action at Shorter AME Church in Denver in November of 2019. We invited the community to come and learn about this problem. 600 people showed up. We called for Chief Pazin to change DPD's operations manual, training of officers, and to begin collecting data on the use of this bias practice. Chief Pazin agreed to work with us, and we have built a solid relationship built on mutual respect. Denver Chief Pazin and his staff listened to our research and our team's input. They continued to work with us as valued partners as they made changes to their Showup policies. He and his staff have rewritten their policies, started collecting data, and created an exemplary training video. As a result, Denver has just become the first law enforcement department in the nation to collect data on Showups. But we know that making a change in one location doesn't solve the problem from all the other cities in Colorado. BIPOC individuals don't only live in Denver, and that is why we sought to bring legislation that will provide a statewide solution. We believe the state of Colorado is a national leader in police reform and can do better by creating a fair and just process for conducting Showup identifications and providing guidelines for admissibility in court. I would be remiss if I didn't thank all the many stakeholders across Colorado who met with Together Colorado on this issue. This truly is a collaboration of justice reform done right. And now I introduce our wonderful representative, Jennifer Bacon, our House sponsor of our bill.
Thank you, Marilyn. It is truly an honor to be here today to be able to partner with Together Colorado. Good morning, everyone. My name is Jennifer Bacon. I represent House District 7, which is Northeast Denver from Monaco all the way east towards the airport. And I start with that because part of the privilege that I have in bringing this work is on behalf of my very own constituent, Sharon Battle. Her son is not only a constituent, but I also have the privilege of serving on our Denver Public School Board. So it's one of our students and therefore my family. I think what is really important about this bill is that we get to put on the table and articulate what bias actually looks like in action, and also what is the impact on families. You know, the truth of the matter is the criminal justice system is a very sticky place. Once you're introduced to it, it is very hard to get out. But also it is a place and space that marks someone for the rest of their lives. Not only does someone have to figure out their finances to be able to fight for their innocence, but once you are arrested, you have to tell everybody about it or tell people in job applications, housing applications, scholarships. And so every time we talk about communities of color being disenfranchised or being oppressed in all of these other areas like housing, education, access to healthcare, we have to be critical of the criminal justice system and what we are doing to funnel people into it so it keeps people out of so many other spaces. And so this bill really is brought to really end that cycle, to qualify a Showup identification that it is necessary is critical. The way that they have been done before has been loaded with bias and therefore unfairly putting so many more people, particularly people of color, where we know there are issues around identification with witnesses across multi-ethnic lines. We are funneling them into the criminal justice system. And so for me as a legislator, we were sent here not just to make laws, but to undo things that have been keeping people in their place. And so for me, this is an incredible privilege and honor to dismantle that kind of practice. I do want to give a shout out to Together Colorado, because given the amount of work that they have done to bring this bill, not only to myself, but to my colleagues, I'm pretty sure Sharon Battle probably has earned a law degree over this amount of time and work that she has done. And so I'd welcome her into my fictional law practice. You know more than I do. But I just want to call out some numbers. Together Colorado met with 55 of the 61 Democratic legislators. They met with 49 stakeholder groups, including police chiefs, district attorneys, public defenders, victims advocates, to be able to spread this news. And for someone, myself, I'm a former teacher, you know, we've been talking to young people about civics, not enough probably, but you know, we all know the song, I'm Just a Bill here on Capitol Hill. This group functionally lived out the promise of true civics in action. And I'm saying this so that my colleagues who are listening and all of our communities who are listening, the passage of this bill is so deeply deserved because you put in the work, and you put in the work on something that is very real and a lived experience. And if we can't pass a bill when our stakeholders come together to identify the issues that have deeply impacted them, and we as legislators cannot receive that and be able to create different outcomes for our own community, then I really fear for our democratic processes. So the passage of this bill is rightly owed and deserved, if not for the people who put their blood, sweat, and tears in it. They have done everything to be sure we can be collaborative in this process. In this day and age, after the events of last summer, it is incredibly important that we begin to work together. And so the example of together working with Denver Police Department is also something to put a spotlight on. So again, thank you. It is an honor of mine to be able to sponsor on the House side. And now I'd like to introduce our Senate sponsor, Senator Julie Gonzalez.
Thank you so much, Representative Bacon, and thank you to everyone who has engaged in this effort through Together Colorado and through all of the stakeholder work that has been done, because this is actually what co-governance looks like. My name is Julie Gonzalez, and I have the honor and privilege of representing North, West, and Downtown Denver in the Colorado State Senate. And I've worked alongside, long before I was a legislator, I worked alongside Together Colorado as an organizer, fighting for justice outside of the Capitol. And now to be able to do this work from this position is just such an honor and a privilege. You know, what is interesting about Senate District 34, my community, is that it is really one of the haves and have-nots. You know, some of, you know, downtown Denver, some of the most, you know, the center of the capital of the state of Colorado. And yet my Senate district, my community also contains some of the census tracts that have the lowest income census tracts in the state, right next to each other. And so, and that inequality is exacerbated in moments of crisis. And I know firsthand that my communities here in Denver and communities across this state, communities of color, low-income communities, are often over-policed and yet under-resourced. And that status quo is not working in my community, and it's not working in too many communities across this state. And so as a legislator, my work is really, I see my work as making our criminal legal system more just, removing bias, and that is the work for so many of us engaged in this effort. We've abolished the death penalty. We've encouraged the Department of Corrections to expand parole. We've prohibited ICE from conducting unconstitutional arrests in our courthouses. And I'm so proud to be working alongside Representative Bacon and you all today, because it is a continuation of that work to make our systems more just. And it fits this policy, HB 1142, specifically around Showup practices, is just part of a larger effort in our state and across this country to advance justice and fairness, and to hopefully lead to less bias and fewer people getting caught up in the incarceration machine. And so I do want to just say that the way that we engage, that we as community engage with law enforcement, the way in which our communities have trust, and the way in which we ensure that that we extract bias from those encounters, that is at the heart of what this legislation is about. And I want to just, reaffirm that this is part of community showing up to law enforcement. This is part of community saying, hey, listen, this is these practices have created harm in our community, and let's move forward and work to transform those policies at the local level, at the state level, and they're also part of the national effort. And so it's why I'm just really excited and honored to be able to now introduce Ms. Sharon Battle, who is going to tell us exactly what these policies, why this need for policies are so important, and how Showup practices have impacted her and her family directly. Ms. Battle, I'll turn it over to you.
Thank you, Senator Gonzalez. Thank you, everyone who's here, who's listening. I am a mother, an Air Force veteran. I'm a woman of faith, and I'm here to ask everyone who in any way listen to support House Bill 21-1142. And I especially want to give thanks to you, Representative Bacon, for listening into your community. And you as well, Senator Gonzalez, because I know the same thing impacts your community just as much. But I'm here today asking for safe passage for my children, my sons and daughters, so that they can walk safely down the street, so that they can live in their own skin and feel comfortable and feel at home in our neighborhood, in our city, in our street, and in fact, in our nation. A couple of years ago, my 17-year-old son was coming home from a date. About a week before his high school graduation, he was walking home when stopped by police. As a Black mother, that's one of my worst nightmares. And on the night this happened, we didn't have any idea where my son was. We were fearful that something really, really tragic had happened to him. We called his girlfriend, and she said he had left her house long ago and he should have already been home. He wasn't answering his phone. And I had this tracking app, so I was watching this tracking app as it tracked him farther and farther and farther away from home. He wasn't answering our calls, and eventually the tracking app went downtown, and that's where it stopped. My husband drove downtown to search the streets where the phone showed that he was located. So all that path my husband drove while I was waiting by the phone at home, watching the phone tracker. I later found out that my son asked the police to let him call his parents. They didn't allow it. The police were looking that night for a Black male, or Black males, I should say, under 20, wearing sweats, who were armed with a knife that a nearby robbery had happened. Well, an attempted robbery. My son didn't have on gray sweats. He didn't have a knife. And when he was stopped at gunpoint, can you imagine the impact that that had on him? 17 years old, guns pointed at you for walking home with your headphones on. I just can't imagine. He was a mile away from the crime scene. The police put my son in handcuffs, even though he wasn't armed and posed no threat to them. He was positioned between an officer on either side of him, and then between two police cars. And the police drove an eyewitness past him while they shined the spotlight on him. Since it was so dark, that was necessary, or they felt it was. In that 4.5 seconds as they drove the eyewitness past him in a dimly lit, highly suggestive setting, he was identified by the eyewitness as one of the young men who had attempted to steal her truck. And on that information, evidence, if you could call it that alone, my innocent son spent 3 days in jail, charged with a felony that could have gotten him 2 to 6 years in prison. His only crime, walking while being Black. It took us 6.5 months and a significant amount of money to clear his name. During that time, he was constantly pressured for a plea deal to a lesser offense, but he didn't do that. And he wouldn't do that because he had community standing by his side. He had us as his family standing by his side. So his case was eventually dropped after 6 months with no explanation or acknowledgement of the anxiety and trauma that he had been put through, or that we as his family had been through. My son has not been the same since. I want you to close your eyes and imagine that this happened to your son or your daughter, that they didn't make it home one night and you couldn't find them, that they spent time in jail and maybe the outcome was different for them. And they ended up spending the 2 to 6 years in prison. That's not a community of human dignity. And that's what we're looking for. We want to change this system so that it's fair to all and that it promotes the human dignity of all of us. Thank you. I apologize for that extreme emotion, but I would like to introduce you to a powerful lawyer and someone who's defended people in my son's situation, Amelia Power. And that name speaks for itself. Amelia.
Thank you, Sharon, and thank you so much. Every time I hear your story, it is so powerful. I became involved in this case, or with this bill, because of Miss Battle's story and the story of her family, and hearing about the heartache and the injustice that they suffered. As a criminal defense attorney and a former public defender, I know this issue about show-up IDs and the heartache and the injustice all too well. And while there are many issues that 1142 would go to fix, I want to focus this morning on why the limitation on admissibility that is in the bill is so important and such a vital step forward. In 2019, our Colorado Supreme Court wrote in an opinion in Garner v. People, eyewitness identifications are extremely powerful evidence. There is almost nothing more convincing than a live human being who takes that stand, points a finger at the defendant and says, "That's the one." But evidence is also fallible. Indeed, annals of criminal law are rife with instances of mistaken identification, precisely because identification testimony is so persuasive. A mistaken identification can lead to a wrongful conviction. Despite this powerful statement, the current state of admissibility in Colorado case law is that an eyewitness identification can be highly suggestive. For instance, in a 2017 Colorado Court of Appeals case, People v. Folsom, the discrepancy between the eyewitness identification and the ultimate appearance of the person who was subject to this show-up ID, the court found highly or distinctly troubling. And yet still, that ID was allowed to proceed at trial and allowed to be made at trial, because the standard for admissibility in Colorado is currently that it cannot be impermissibly suggestive. And the way that courts determine how that's done is that they look at 5 factors that really go to more not to what HB 1142 addresses, but what the reliability is of the initial identification. So 1142 really takes a giant step as far as making certain that the various the various mechanics of these identifications are addressed. Impermissibly suggestive test is a very high bar for an accused person to meet, and often means that those incorrectly identified have to go all the way through trial, as Ms. Bada was talking about, has to at least go through a motions hearing, maybe all the way through trial. And again, these identifications, even if highly disturbing or highly troubling, can still be admitted at trial against people. And the important thing is that the admissibility requirements in 1142 go far to fuse scientific reliability with the legal factors that are already in the case law, to make certain that important identification issues that should be at the forefront of any case, such as cross-racial identification and unreliability of eyewitness testimony, do not linger on the back burner, but are addressed early and efficiently. When thinking about this, I was reminded of a case of my own where there was a person who the police officer just took the eyewitness, showed him through a window. The only identification we had was that the person was in a red shirt, which my client happened to be wearing, and this was from 100 yards away, and the person was wearing a red shirt surrounded by police officers. Ultimately, that identification was let in at trial, and I was thinking about how 1142 would change that. So this is exactly the type of situation where we have the scientific tools, we know what should be done, and if it was done properly, then that would be a much more reliable identification. And if it was done poorly, we would be able to talk about it earlier with the prosecution and try to resolve this again more efficiently and earlier. Identification is always at issue in criminal cases. Identification is always an element that must be proven beyond a reasonable doubt. Making sure that identifications are done correctly and reliably or otherwise cannot be used is foundational to the principle that every person in our criminal justice system is presumed innocent. And that is why I very much support House Bill 21-1142. And next, we will hear from Christopher McKee.
Thank you very much. I'm here just to address that today, the time is really now for this bill. In fact, it's long overdue. It's long overdue. We could have avoided what the battles went through. And so Sharon, I want to thank you for your powerful, emotional testimony. That's exactly what we need to hear. We need to really address the fact that there are costs to suggestive ID procedures, incredible costs. There are wrongful convictions. There are wrongful detentions. There are lost lives. There are changed lives, as Sharon talked about how her child is not the same person today because of what happened to him when he was stopped, arrested after a show-up identification. When I say that the time is now, it's clear. Over the past several decades, we have learned primarily through rigorous scientific research, social science research, and then also from DNA exonerations that the criminal justice system throughout the United States, that there are serious concerns regarding the potential unreliability of eyewitness identifications. When I say rigorous social science research, that predates when I became a lawyer. Since the 1970s, social scientists have been invested in looking at the fallibility and fragility of eyewitness identification, how memories don't necessarily work the way that we think they work, and that the conditions surrounding eyewitness procedures are the very reason for why mistakes happen. And when I say mistakes, I don't want to minimize what they are. They destroy lives. DNA exonerations have told us that eyewitness identifications have been the primary reason for false convictions that have placed people on death row. There are many different ways to look at this, but if you were to go to the Innocence Project's website, you would see that more than any other cause, eyewitness identifications have led to wrongful death row convictions. And ultimately, DNA exonerated those individuals, thankfully. It is second only to junk science, other junk sciences in the forensic sciences, but eyewitness identifications are the primary pipeline to wrongful convictions. So all of this has revealed that flawed eyewitness identification is a prison pipeline. And this is a prison pipeline that happens after trials. And so that is that it goes to verdict and juries rely upon these bad identifications and identification procedures. And it also is largely responsible for a lot of the coercive plea negotiations that happen. If you're not aware, most cases are resolved by plea. And that is the vast majority. You can look at different numbers, but it is in the neighborhood of 90% of all cases, maybe as high as 95% of all cases are resolved by pleas. And as Sharon mentioned, there was pressure for her son to take a lesser plea, to take a misdemeanor and resolve this case and not risk a felony conviction. But those kind of coercive conditions happen and flow from the problem of that identification procedure. I know that the lawyers will tell them that they need to go ahead because the power of that identification, as Amelia talked about. So it's beyond dispute. Verdicts of guilt rely upon flawed forensic science evidence. And so I support this bill. I think it's a wonderful step, and I do think the time is now for it. So now I'll turn it back over to Pastor Trussell. Thank you.
Thank you, Chris. And thank you everyone, just for all the ways in which you're telling our story and staying on time. I didn't have to say one thank you. So there you go. That was great. We're really sorry that Pastor Timothy Tyler from Shorter AME Church was unable to join us here at this press conference at the last minute. For those of you who have met Pastor Tyler, you know that I pale in comparison to his personal experience and his longtime work in civil rights. He plans to give his remarks during the committee hearing tomorrow afternoon. What I can do is let you know that Together Colorado has multi-faith leaders across the state who support this bill. 186 faith leaders have signed their support to it from La Vera, Pagosa Springs, Wellington, Gypsum, Pueblo, Canyon City, Colorado Springs, Grand Junction, Fort Collins, Greeley, and Denver. As one of those faith leaders who signed that bill, I can tell you that the hours I work as a volunteer faith leader with Together Colorado over the last few years have been heart and mind stretching. People from all walks of life are transforming justice for everyone involved on all sides of the law in respect to their dignity, for victims, misidentified people, law enforcement, court workers, and people in jails and prisons. Our wide and varied faith traditions essentially teach us to love and care for our neighbor. States and law enforcement agencies across our whole country have recognized the risks inherent in eyewitness cases. Many have embraced best practices to guard against the risk of misidentification, but not all law enforcement agencies have been required to adopt these best practices. The foundational concept of innocent until proven guilty must apply to all individuals, regardless of race or place, and be put into practice consistently by all law enforcement. When we morally lead, we can make Colorado a state where each person on all sides of the law can thrive. And now I would open it up to press questions. You can put those in the Q&A, and we will allow those who are most appropriate to tackle those questions. And I am not seeing any questions. We must have covered it really well. All right, I'm going to give you just a few more seconds. Is there anything any of our speakers would like to say before I bring us to our close?
Yes. I would like to say that keep in mind that my son had success in this because there were so many people, Together Colorado, so many people that were in that courtroom every day. So this is nothing new. This is not an isolated incident. It happens everywhere across the state and the nation.
If I may, I just want to let folks know that the committee hearing, the first hearing on 1142 will take place tomorrow. Representative Bacon will be carrying this in the House. And its first committee hearing is scheduled for tomorrow, March the 31st at 1:30 in the House Judiciary Committee. We really do encourage folks to reach out to their legislators to let them know about the importance of this bill and just why it is so important for our larger criminal justice reform efforts. And so shout out to everyone who is engaged in this effort, to Representative Bacon for leading this in the House. I can't wait for it to come over to the Senate. Yeah, I just wanted to let folks know about that.
Thank you, Senator. We do have one question. I think perhaps either Representative Bacon or Marilyn could answer this question. What are the provisions for collecting data on Showups, and why is this data important?
Do you want to take that, Representative Bacon?
Sure, thank you. So the data that we hope to collect is really about the touch points when it happened, as well as data that can help us understand the outcome. Ultimately, the data is important for public accountability. And so what that means is, how can we as community better understand what's happening, and also be able to use the data to leverage improvements in the practice. And so we know that we've seen, for example, with other bills, we've required policy changes. But if we do not have something to anchor those changes to by way of an accountability tool, it may not happen. So that is the primary purpose. Is there anything else you'd like to add?
I would just add the details. For instance, in Denver, we are getting race, gender, type of crime that was committed when the Showup or identification was used, and whether that was used or not to arrest the person, if the outcome of the Showup. This would all roll into last year's Senate Bill 217, so it wouldn't require police departments or law enforcement across the state to do but another few more checks on the data boxes that we're already requiring.
And one last question. The question was answered in the Q&A, so I think we're okay there. As we close, again, the reminder that Senator Julie Gonzalez gave us to tune into the hearing. That hearing is not watchable, it is an audio, and you're able to tune into that hearing and listen to it. My understanding is you can also listen after the fact, that those are recorded and archived. So, so that is available. Members of the press on this call have contact information for follow-up as needed, and you can contact the bill sponsors' offices directly. We know that time is a precious commodity, and that all of you chose to share it here with us today says a lot about what your priorities are and what your priorities for our community are. So we thank you so much for choosing to spend your time here today. We're grateful for that, and grateful to all of our speakers, to our sponsors, to our experts, and to our Together Colorado volunteers and organizers who made this time possible. And thank you to everyone across the community who joined us today to listen and to learn. Thank you everyone for coming, and now I wish you to be safe and be well. Take care.